Good day dear students. In this video we shall see about module 3 that covers the part of amendments of Indian Constitution. We shall see the various methods of the constitutional amendments and some of the very important constitutional amendments and the recent amendments that have been added to the constitution in the recent days. So we shall see the second and third topic of this module, that is amendments to the constitution, the method of constitutional amendments, and some of the major and important constitutional amendments will be seen and covered in this module. So what do we mean by amendment? Amendment is a statement that is added to the existing law or clause or in order to improve a proposal or improve that particular clause or law or the document. In the case of constitution, amendment can be defined as a statement that is added to or revises or improves a proposal or document, that is a bill or a constitutional part, and the procedure for the amendment is laid in part 20 article 368 of the constitution. So article 368 under part 20 clearly explains the various processes and procedures for the constitutional amendment or the methods that is to be followed for the constitutional amendment. So this, in spite of all the rules and regulations, there have been over 90 amendments to our constitution. So our constitution is a evolving one, and it was enacted in the year 1950, and after its enactment in 1950 totally 90 amendments have happened. So from this we can understand that our constitution is developing or evolving one, and the Indian Supreme Court has ruled controversially that not every amendment or constitutional amendment is permissible, and the amendment should respect the basic structure of the constitution, and the basic structure of the constitution cannot be changed or it is immutable. So the amendments of the Indian constitution have been done for the purpose of variation or addition or cancellation of the provisions. So if it was found that certain rules and regulations have to be deviated, or it is not relevant, or it has to be improved upon, in such cases the amendments have been done. So since the enactment of the constitution on 26th November 1949, there have been 104 amendments till the year 2020. So latest is 104th amendment until the year 2020, and number of bills are introduced in Lok Sabha and Rajya Sabha for further improving the constitution. So Parliament has been given the responsibilities. The Parliament has been given the responsibilities and rights, and it is the responsibility of the Parliament to improve the constitution. So constituent power has been bestowed on the Parliament, using which the changes in the Indian constitution can be made regularly. However, the basic structure of the Indian constitution cannot be changed under any circumstances. So the basic structure has to remain the same. So if any amendment violates the basic structure, then it can be revised or changed, or it can be taken back. So the constitutional provision for amendment of the Indian Constitution. So the part 20 of the Constitution of India explains in detail the process of amendment of the Constitution. What are the processes to be followed, what are the procedures to be followed, all these are laid very in detail in the part 20 of the Constitution. So the article 368 specifies about the power of the parliament to amend the constitution and the procedure that is required to follow. It also mentions in that article that there will be no limitations on the constituent power of the parliament for amending it by adding or removing or improving any provisions that are required to be made in it. So we shall see in brief the procedure of the amendments of the Indian Constitution. So the method of an amendment of the Constitution is considered to be a highly complicated procedure. So it has been laid in the Constitution in Article 368 Part 20, but it is not so simple. Amendment process is not so simple. So amendment, there are many methods in which the amendments can be done. So the amendments can be made by various methods which have been modeled based on the South African Constitution. So the initial step of an amendment of the Constitution is to introduce the bills regarding the amendment in any one of the houses of the parliament, that is either in the Lok Sabha or the Rajya Sabha. Then the bills can be passed by a simple majority of the parliament. Okay, before, once it is passed in the parliament by the majority, then the bills are sent for president's approval or president's assent. There can be a voting among the members of the parliament that is present during the passing process. So if the majority of them vote in the favor of the amendment, then it is considered as accepted. And amendment can also be finalized if 2/3 of the members of the parliament present vote in the favor of that amendment. However, the number of voters should be more than half the total number of members of the parliament. So this method is known as special majority of the parliament, and in some cases bills for amendments to the Indian Constitution is to be finalized in this method may also require ratification of the legislatures of at least half of the Indian states. So Indian states also have to give their approval. So like I explained in the previous slide, this slide also explains about the process of amendment of the Indian Constitution. That is the Parliament's role in the approval of the amendments, or Parliament's role in taking the decision in amendment of the Indian Constitution. In the coming slides, we shall see about the Constitution Amendment Act, or some of the very important and major amendments that have been done to the Constitution. We shall only discuss about the major amendments, not all the amendments. So the 7th Amendment of Indian Constitution was needed to implement the recommendations of the states reorganization, or the formation of the states. So formation of the states happened in the year 1956. Hence this was included in the 7th Amendment Act of the Constitution. And the formation of the states happened on the linguistic basis. That is, Tamil speaking state was formed as Tamil Nadu, Kannada speaking state was formed as Karnataka, Malayalam speaking state was formed as Kerala, Marathi speaking states were combined together to form Maharashtra. So the based on linguistic basis, the division of the states had happened in the year 1956, and this was included in the 7th Amendment Act of the Constitution. So, some of the important facts are and its implications. So, the area and boundaries pertaining to the states, union territories were present in the first schedule of the Constitution was completely revised to reflect the changes that was brought by the reorganization scheme. And the 7th Constitutional Amendment amended the Articles 1, 3, 49, 80, 81, 82, 131, 153, 158, 168, 170, 171, 216, 217, 220, 222, 224, 230, 231 and 232 in one form or the other form. And it also inserted new articles and amended the Part 8 and Schedule 1, 2, 4 and 7. So, the fourth schedule also lays down the allocation of the seats of the state council, and this was also completely revised. It had major implications, so it was needed to make amendments to implement the schemes of the state reorganization and also to make some changes in certain provisions of the constitution relating to high courts and high court judges and the executive power of the union and the states. So this was done in the 7th Amendment Act of 1956. Detailed changes and the list of changes that have been done is explained in the notes that has been provided to you, and in the notes you will find all the major changes or major implications that the 7th Amendment Act brought upon in the Constitution. The next is the 9th Amendment Act that happened in the year 1960. So the Constitution's 9th Amendment Act that was passed by the Indian Parliament in the year 1960 was to amend the Constitution and to give effect to the transfer of certain territories to Pakistan. So there was an agreement between the government of Pakistan and government of India, and in order to maintain the peace with the neighboring country and to have a long lasting peace with the neighboring country, 9th Amendment Act was passed, and it gave certain small villages to the neighboring country, and also certain villages were taken from Pakistan in order to mark the territory of Indian Union, and this was consequent to agreement with Pakistan for settlement of disputes by demarcation of the border villages. The next is 10th Amendment Act of the Constitution that was passed in the year 1961. So there were two territories, that is Dadra and Nagar Haveli, and these were added to the Indian Union, and the Constitutional Amendment Act of 1961, that is the 10th Amendment Act that was passed on 12th June 1961, made way for integration of these two union territories in the Union of India. That is, it paved the way for addition of these two union territories into the Indian country. So subsequently, these areas were made part of the Union Territory from 11th August 1961. The major provisions was the first schedule of the Indian Constitution was amended to make Dadra and Nagar Haveli as a part of India, and they were included as the 7th Union Territory. It amended Article 240 subclause 1 to include the Union Territory of Dadra and Nagar Haveli, and it gave the rights to President to make the regulations. So President got the rights to make the regulations so that the peace, the progress and good governance of this territory can be maintained. So it gave the rights to the president to make the rules and regulations for the development of the people of Dadra and Nagar Haveli. So just like the 10th Amendment of 1961, 12th Amendment of 1962 was done to include Goa and Daman and Diu as Union territories of India. So Goa, Daman and Diu were added to the Indian country in the year 1962 after the Portuguese departed from these territories, and this gave the power to the president to make rules and regulations for the development, peace, and progress and good governance of the people of this territory. So the first schedule of the constitution was amended to add Goa, Daman and Diu as part of the union territory, and article 240 subclause 1 was amended so that the president got the rights to make regulations, to make the rules and regulations for the development, for the maintaining of peace and progress and good governance of these territories. The next is the Constitutional Amendment Act of 1972. So basically it changed the characterization of India from sovereign democratic republic to sovereign socialistic secular democratic republic. So the 42nd Amendment Act of 1972 is one of the major amendment acts because it brought in a lot of changes to the basic structure of the constitution. Secondly, the words unity of the nation was changed to unity and integrity of the nation. 42nd Constitutional Amendment Act proves the readjustment of the constituencies for election of Lok Sabha and state legislative assemblies after every census. This was done because after every census the constituencies changed. The constituencies, what to say, the border of the constituencies changed. Okay, and this 42nd Constitutional Amendment Act stopped that process. This was done after every census that was held for a period of 10 years. So at the point of 1971 census, till the holding of the first census after the year 2000, it was held until that year. Next, fixation of the numbers of seats of scheduled constitutional amendment. The 42nd Constitutional Amendment Act that was passed in the year 1972 extended the term of Lok Sabha and state legislative assemblies from 5 to 6 years. So a person holding an office of profit is disqualified from the membership of the parliament or the state legislature, and have the court's power to declare what is an office of profit was seized. Okay, and similarly, disqualification of constitutional amendment of the members of the state legislature was to be decided by the president in consultation with the election commissioner or the election commission of India, and for the state this power vested with the governor. For the 42nd Constitutional Amendment Act, Article 74 and was amended, and it explicitly laid that the President shall act in accordance with the advice of the Council of Ministers. But no such provision was made by 42nd Constitutional Amendment as regard to the state governor. So the state governor was certain discretionary functions to discharge, in respect of which he is not bound by the ministerial advice of that state, or he is not bound by the state cabinet or the chief minister's advice. Next, Article 352 was amended to authorize the president to vary the proclamation of emergency. Earlier he could not do that, so now the president had the right to do it. So for some necessary changes were made in the article 353, 358 and 359 also. Next major point is the proclamation of emergency. So earlier the proclamation of emergency under article 356 required a parliamentary approval in order to operate at the end of every 6 years, but now on this period was extended to only 1 year. So the amendment of Article 357 ensured that laws for a state when it was under Article 356 emergency was not to come to an end automatically, and constitutional amendment after every expiry of the emergency would continue in operation until the state legislature made the required changes. So in addition to this, the 42nd constitutional amendment added few more directive principles, that is under article 39A, 43A and 48A, and article 31C was amended to give primacy to all the directive principles over the fundamental rights, irrespective of their being consistent with any of the rights that has been conferred by the article 14, 19 or 31. So these are the major changes that were taken in the 42nd Constitutional Amendment Act of 1972. Next we shall see about the 44th Amendment Act that happened in the year 1978. So 44th Amendment Act happened in the year 1978. This amendment brought a lot of changes in many articles uh, pertaining to the preventive detention of for a period of more than 2 months can be ordered only by the recommendation of the advisory board. So the right to property was omitted. Earlier it was a fundamental right. After this amendment, the right to property was omitted and it was made as a legal right. And minorities will have rights to establish or run their own educational institutions as before. So this was not at all touched in this 44th Amendment Act of 1978. Next is the Constitution's 61st Amendment Act that happened in the year 1989. So the 61st Amendment of the Constitution of India happened in the year 1989, and this lowered the voting age of all the citizens from 21 years to 18 years. So the people were eligible to cast their vote for both Lok Sabha and the state legislative assembly, that is for Vidhan Sabha, once they reached the 18 years of age. So earlier it was 21 years of age. This was reduced to 18 years of age. So this was done by amending the Article 326 of the Constitution, and which concerns to elections of the Lok Sabha and the assemblies. Good day dear students. In this video we shall see about module 3 that covers the part of amendments of Indian Constitution. We shall see the various methods of the constitutional amendments and some of the very important constitutional amendments and the recent amendments that have been added to the constitution in the recent days. So with respect to the significance of the Amendment Act of Panchayat Raj system, that is 73rd Amendment, we can see that this amendment implements the Article 40 of the Directive Principles of the State Policy, which says that the state will take steps to organize the village panchayats and endow them with such powers and authority that may be required to enable them to function as units of self-governments, and they will have them upgraded from non-justifiable to justifiable part of the constitution, and it has put a constitutional obligation on the states to enact the Panchayat Raj Act as per the provisions of the Part 12 of the Constitution. However, the states will have been given enough freedom to take their geographical, political, administrative and other conditions into account while adopting the Panchayat Raj system, which means that the state has the right to take the required decision with respect to its geographies and other socio-political entities. So in this slide we shall see about the 74th Amendment Act of 1992. Just like the 73rd Amendment Act for the Panchayat Raj system in India that was passed in the year 1992, the 74th Amendment Act of 1992 was brought in to have effective functioning of the urban local bodies. So a new part under 9A relating to the municipalities, Nagar Panchayats for the areas in transaction from rural area to urban area, and the municipal councils for small urban areas and municipal corporation for larger urban areas were incorporated in this 74th Amendment Act of 1992. In simple words, if we can say that the 73rd Amendment is for the villages and the 74th Amendment is for the structure of the cities or the urban bodies. Next is the Constitutional Amendment Act of 1994, that is the 75th Amendment Act. So it provides for setting up of the state level rent control tribunal in order to exclude the jurisdiction of all the courts and except for the Supreme Court as per the Article 136 of the Constitution. Next is the 76th Amendment Act that was passed in the year 1994. So the amendment places the state of Tamil Nadu. So this is pertaining to the state of Tamil Nadu. So as per this, the reservation within the 9th schedule of the Constitution, the government of Tamil Nadu will reserve 18% to scheduled caste, 1% to scheduled tribe and 50% to other backward classes or other backward castes or OBCs. So in altogether 69% of reservation is given to the various classes, that is scheduled caste, scheduled tribes and other backward classes in either education institutions or in public employment. So 76th Amendment Act of 94 is pertaining to the state of Tamil Nadu. The next Amendment Act is 86th Amendment Act that was done in the year 2002. So this act may be called the Constitution's 86th Amendment Act of 2002. So insertion of the Article 21A after 21 of the Constitution. So what does 21A tell? So 21A is with respect to right to education. So the state shall provide free compulsory education to all children of the age of 6 to 14 in such manner as the state may by law determine. So it becomes the responsibility of the state to provide education to all the children between the age of 6 to 14. And next is the provision of early childhood care and education to children below the age of 6 years. So the state will endeavor to provide early childhood care and education for all the children until they complete the age of 6 years. So the amendment of Article 51A, in Article 51A, the Constitution after clause J, the following clause was added, namely, who is a parent or guardian to provide the opportunities for education to his child, or as the case may be, ward between the age of 6 to 14 years, which means that it is the responsibility of the parent to ensure that proper education is provided to the child between the age of 6 to 14. So it is the responsibility of the parent, or if it is a case of guardian, it is the responsibility of the guardian to provide proper education to all the children between the age of 6 to 14. So 86th Amendment Act 2002 is very important, has respect to the education of a child, with respect to the education of the child. So you can also have heard about this as Sarva Shiksha Abhiyan. So this falls under the same category, Sarva Shiksha Abhiyan. The next is Constitutional Amendment Act of 1991, that was passed in the year 2003. So in the Article 75 of the Constitution, after clause 1, the following clauses were inserted. That is, after clause 1 we had 1A, the total number of ministers including the Prime Minister in the Council of the Minister will not exceed 15% of the total number of members of the House of the People. So this was done in order to prevent huge sizes of the cabinet ministers. So the total number of ministers is 15% of the total number of members of the House of the People. That is 15% of the strength of the Lok Sabha is the strength of the cabinet ministers. Next is 1B. A member of either House of Parliament belonging to any political party who is not qualified for being a member of that House under paragraph 2 of the 10th schedule shall also be disqualified to be appointed as a minister under clause 1 in Article 164 of the Constitution. And this was added after clause 1, and the following clauses will be inserted. So, member of House of Parliament who is disqualified cannot be from the House under the paragraph 2 of the 10th schedule will also be disqualified from the ministerial post. So, he cannot hold the post of the minister if he is disqualified from any of the House of the that is either from Lok Sabha or the Rajya Sabha. Also, in Article 164, the following clause was also added, that is, total number of ministers including the chief minister in the council of ministers in a state will not exceed 15% of the total number of members of the state legislative assembly. So provided that the ministers including the chief minister will not be less than 12. So here it puts a upper cap and a lower cap on the strength of the cabinet of the state. So it tells that it should not exceed 15% of the strength of the Vidhan Sabha, and at the same time it also tells that it should not be less than 12. So at least 12 members should be the ministers of that particular state, plus the number of ministers cannot exceed 15% of the total strength of the Vidhan Sabha. Article 361A of the Constitution also uh, specifies addition of Article 361B, that is, a member of the House belonging to any particular political party who is disqualified for being a member of the House under paragraph 2 of the 10th schedule will also be disqualified to hold any remunerative political post for the duration of that particular period, that is commencing from the date of his disqualification to the date of his uh, term of his office of such member would expire or until the date on which he contests the elections for the house and is declared as elected, or he comes wins and comes back to that particular house, whichever is earlier. So 10th schedule of the constitution was also amended. So in this 10th schedule, paragraph 1 clause B, the words and figures of paragraph 3 and has maybe the case of 1 shall be omitted, and paragraph 2 in subparagraph 1 the words and figures of paragraph 3, 4 and 5 of the words and figures of paragraph 4 and 5 shall be substituted. So basically this amendment brought in a structure in the cabinet, number of ministers for the cabinet, and also it also brought in a rule wherein the person who is elected for either of the member of the house only can become a minister. A person without any seat in the house of people of the house or in Rajya Sabha or in Lok Sabha will not be a minister. So this was brought in to cap the powers of the people, even if they are not members of the either of the houses. They cannot chair as the ministers, or they cannot chair as the uh, members of any committees of the parliament. The next amendments are the 94th Amendment Act that happened in the year 2006. So this was to provide for a Minister of Tribal Welfare in the newly created state of Jharkhand and Chhattisgarh, and also Madhya Pradesh and Orissa. So a new post was created, that is Minister of Tribal Welfare, for the states of Jharkhand, Chhattisgarh, Madhya Pradesh and Orissa. 95th Amendment Act was passed in the year 2009. So this 95th Amendment of the Constitution of India, officially known as the Constitution Act 2009, extended the period of reservation of seats for the scheduled caste and scheduled tribe and representation of the Anglo-Indians in the Lok Sabha and the State Legislative Assembly for another period of 10 years, that is up to 26th January 2020. The next Amendment Act is the 100th Amendment Act that happened in the year 2015. So Constitution said 100th Amendment Act in 2015 ratified the land boundary agreement between India and Bangladesh. So the act amended the first schedule of the Constitution to exchange the disputed territories that was occupied by both the nations in accordance with the 1974 bilateral LBA. So India received 51 Bangladeshi enclaves covering 7,110 acres and in the Indian mainland, while the Bangladesh received 111 Indian enclaves covering 17,160 acres in the Bangladeshi mainland. The next is the Constitution's 101st Amendment Act that happened in the year 2016. So there are several articles in the constitutions of India which define the financial relations between Union and the states, and since a GST bill was introduced in the Parliament, and GST bill involves huge interest of the state governments, and such a historical tax reform cannot take place without making necessary changes in the constitution. So for this purpose the 101st Amendment Act of the Constitution was passed, and this act received the assent of the President of India on 8th of September 2016. So the important changes made in the Constitution via this law due to the implication of the GST. Next is Article 104 104th amendment that was passed in the year 2000, 2020. So the 104th Amendment Act of the Constitution was passed in the year 2020. This was to extend the reservation of the seats for scheduled castes and scheduled tribes in Lok Sabha and states assemblies from 7 years to 80 years, and this was removed. It removed the reserved seats for the Anglo-Indian community, since this community was not very much there in India. The reserved seats of the Anglo-Indian community was removed in the Lok Sabha and the state assemblies.